Okay, yeah, this is case number 21 CR 191. State of Ohio, this is John E. Smith. Both for the state, Assistant Prosecutor King, Defense Sheriff Captain Hackner, John E. Smith.
Yes.
All right, the defendant is charged in a 5-count indictment, 3 counts of rape, 1 count of gross sexual imposition, 1 count of illegal use of a minor in nudity-oriented performance. Matter set for trial. I'm not sure now what I think they did appreciate. In any event, matter set for pre-trial today, and I've been provided with a pleading guilty form, Mr. Smith, which indicates that you're going to withdraw your not guilty plea, be guilty to amended charge in count 1 of rape. First degree felony. Now, this is a 3-page document. On page 3, there are signature lines, and I'll just hold up there so you can see. Right there, there's a sentence that says, "I enter this plea voluntarily." Right below that, here's the signature, John E. Smith. And did you sign this agreement I'm looking at, Mr. Smith?
Yes, sir.
When did you sign it?
I believe last Tuesday.
Okay. And you were at your attorney's office?
Yes.
And she went over it with you and explained everything to you before you signed it? Okay. Thanks. Keep your voice up if you would, please. And when you signed this agreement, Mr. Smith, did you understand that this was an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing hearing?
Yes.
Right now, do you feel you had enough time to fully consider this matter before you made this decision?
Yes.
And are you entering into this agreement to plead guilty voluntarily?
Yes.
Okay, now page 1. Let's see. In count 1, you're currently charged with rape. Under 290702A1B of the revised code of first degree felony. And as charged, it carries a potential of life without parole because it's alleged that the victim in the case was less than 13, which is at the time, which makes it a degree of crime. And then also it's alleged that the alleged victim was less than 10 years at the time, and that it would make it a life without parole plea. Now, the amendment, I assume, that's being proposed is to delete the allegation of the alleged victim being less than 10, which then makes it a sentence that's possible of 10 years to life. That's correct. And I believe that's the only sentence. That's correct. You agree with that? Okay. And so that's what's called a lesser offense. Under the law, if evidence supports in a crime, if it doesn't support the charge in the indictment, but it does support a lesser charge if one of those elements isn't proven, it's called a lesser included offense. And so what this is doing then, instead of having a trial to see what the jury would do, is it's basically the state has agreed to delete that part of the allegation so that it'll just be the allegation that the victim was less than 13 years of age at the time. And so what that does is reduce it from a life without parole sentence to a possible maximum sentence to a term of 10 years to life. Okay, you understand that?
Yes, sir.
Okay. All right, man. You're agreeable with that now?
Yeah.
Okay, we got you. Okay. Now, are you facing any felony charges in any other jurisdiction?
No, sir.
Okay. Now, are you currently on probation, community control, parole, or post-release control for a felony?
No, but I do go to probation.
Yeah, that's just for this case. I mean, for any previous case, are you on probation, or community control, parole, or post-release?
No, sir.
Okay. All right, now, under the law, in this case, Mr. Smith, the sentence would be 10 years to life, and that would be, the 10 would be mandatory, because I understand, and then you would be considered for parole after 10 years. And that would be up to the parole board. And so, makes no sense, but it's the way the law is that is it if you, because this could be kept in prison for the rest of your life, if you're released early, you're on parole. But we also have post-release control in this state, which applies to all first-degree felonies, and so it's somewhat inconsistent. Now, parole, I'm not sure, parole's up to the parole board. They can decide how long you should be on parole, and I don't remember anymore what the maximum is, but, you know, typically it depends on the charge, but it could be, and those are usually pretty serious charges, usually they're homicide or major sex offenses like this. And, you know, it could be for, you know, any period of time up to what they say. However, under Ohio law, it's mandatory that any person who's released from prison on a sex offense serves 5 years of what's called post-release control supervision. In reality, there's really not much difference, if any, between being on parole and being in post-release control. In terms of the supervision, now the consequences are different, but not the actual nuts and bolts, so to speak. So, if you're on parole and they determine that you have failed to comply, they can return you to prison, make you serve the rest of the term up to life. If you're on post-release control, then you'll be on parole. I mean, I don't exactly understand, you know, what the offenses the legislature did a very good job of thinking about this, and definitely adopted it, which is an unusual. But in any event, on the PRC, post-release control, if you violate those conditions, they can return you to prison in increments. In other words, they can make you serve up to 9 months or less, whatever they might be 30 days, 96 months. Actually, it'll be 9 months for one violation. There's a cap, a cap of whatever term was imposed for all violations. And in this case, I assume they used the 10, which is 5. But I don't know, because again, it's in conflict. But if you committed a felony while under post-release control supervision, then in addition to every sentence the judge communication gave you on the new sentence, the judge then sent you for committing that crime while under post-release control, in this case, an additional 34 years, or comes left on that 5 years in that for post-release control, whichever is greater. If that occurs, that would have to be served second. Now that's different from parole. If you committed a felony while on parole, it's a violation of your parole, and they can send you back to prison again to serve the rest of your term, which could be life. So, I just want you to be aware that I can't tell you how they reconcile those two things. I don't know that anybody knows. I don't know that it's happened. But in any event, those are the way it worked. Parole, I will tell you this, parole would trump, because the original sentence says 10 years to life. And so, if you committed any violation of parole, you could go back to the rest of your life. If they limited it to a violation of your PRC, then 9 months at a time, up to half or 5 years, will be the max that they can send you back for. But they always have the parole. And my hunch is that it would use parole. But again, I can't tell you. So I just want you to understand that, you know, I don't know if your attorney thinks she can answer the question any better than I can. Because we just don't know.
You're thoroughly confused.
So, but I just want you to understand that those are, you know, potentially any violation could send you back to prison for the rest of your life. If they wanted to use PRC, it would be in increments up to 9 months at a time, up to maximum 5 years. Okay? Do you have any concerns about that, or does that have any impact on your decision here today? Okay, thank you. It wouldn't, I mean, like I said, I'd be telling you the same thing if you've gone to trial. So, you know, it doesn't apply differently whether you plead guilty or if you're trial. So, you know, I would still, if I were sentencing you and if you were found guilty by a jury, I'd be telling you the same thing. Because I don't know what else to say at this point. All right, now, under the law, this is a mandatory sentence, so the question of community control cannot be considered. I can't give you community control, which is probation. So you have to go to prison. Also, that means you can't get judicial release or early release from that 10 years because of it being a mandatory sentence. You understand that? Okay. Now, the charge in count one currently reads that on or about the period of September 26, 2008, continuing through September 26, 2017, in Highland County, Ohio, you did engage in sexual conduct with ZC, who is not the spouse of Johnny Smith, or being the spouse but living separate apart from said Johnny Smith, and said ZC being less than 13 years of age, and being less than 10 years of age, and then parentheses vaginal intercourse, which I think is simply to identify what the applicant act is alleged, in violation of section 290702A1B. So that's where you're currently charged with, which is a life without parole. Now, the amended charge would be to delete the last portion of that sentence of and being less than 10 years of age, and that would then make it, like I said, this 10-year to life sentence. Now, you understand what it is you're charged with in the count one as amended, reduced, and what the state said you did, when, where, and how they alleged that you did it. And again, you understand the possible, or not possible, the penalty for this offense. Well, one other thing I did not tell you is that it also carries a collateral consequence, what we call it, which is a requirement to register as a sex offender if you're released from prison after you're sentenced there. And that requires registering at the sheriff's office every 90 days. I'll go through that if you end up pleading guilty, but just want you to be aware that that is a requirement that if someone is convicted of this, they be required to register as a sex offender for the rest of their life. Understand that? Yeah. Okay. Now, you discussed the nature of this charge, the evidence in the case, possible legal issues in the case, possible defenses you could try to raise at trial, and the possible outcomes of a trial with your attorney.
I'm not sure I understand.
Well, you discussed the case. You hired Ms. Hackney, right?
Yes.
All right, so you discussed the matter with her about what the charge is, changing the charge,
Yes.
What the legal issues there might be in the case. I mean, not just today, but during the course of the representation.
Yes.
All right. And so you've discussed everything about the case.
Yes.
All right. And are you satisfied with her advice and confidence in this matter?
Yes.
All right. Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Do you take any prescription drugs that affect your understanding to what's happening or your ability to comprehend things?
No, sir.
All right, now, well, has anyone threatened you? Maybe plead guilty here today.
No.
Right now, the agreement states on page 2, there's some bold print and underline. And I'll read that to you as follows. The defendant will enter a plea of guilty to count 1 as amended. The state will dismiss the remaining counts. State defense shall recommend 10 years to life. The defendant shall be a tier 3 registered sex offender. Now that's what was credited bold and underlined. Is that your understanding of the agreement?
Yes.
Does anyone promise anything other than that case plead guilty to that?
No.
Yeah. And again, you understand that there's only one sentence possible that's mandatory, 10 years life. Okay. Now, do you hold any kind of license or certification from the state of Ohio, any trade, occupation, or profession that's regulated by a state agency?
I do have water license.
Okay, for
They do
water
that.
treatment plants and things?
Yeah.
Okay, that's no longer valid?
It goes back to the EPA.
Okay,
I have no control over that.
the Ohio EPA?
Yeah,
Okay,
because I'm retired.
all right. All right. So, if that's still a valid license, it's still a valid license, you think, or is it expired?
Well, when I retired, I can no longer use it.
Okay, so you don't think it's valid?
Probably.
Because the reason I'm getting into this is because under Ohio law, if there's a felony conviction, then the clerk of court is required to send the notice of the conviction to that agency so that if it is a situation where there could be some sort of action taken, then they could do that. It's not that we tell them that you should lose your license. It's just that, sometimes, most of the time, in fact, a felony conviction could be a basis for disciplinary action on the license. So that's why I asked about it.
Oh,
Okay. All right. Now, you have constitutional rights you have to understand before I separately. First, you have right to counsel. You have employed Ms. Hackman to represent you. Now, in the event that you could not afford to pay her to represent you to complete the case, the court would appoint an attorney for you at no cost. And so the reason I bring that up is I just want to make sure that you're not entering into this agreement to plead guilty because you're concerned that you're not going to be able to continue to pay her to represent you. Does that have anything to do with this, to your decision? Okay. Right now, you have a right to have a jury trial in this case, in which 12 people would be selected from a group of citizens that reside in Highland County who would be summoned for jury duty on your trial day. After they were selected, the 12 would be selected. Then the evidence would be presented to that jury, and then they'd be instructed on the law, and then they would decide whether or not the state proved your guilt on the charge. And that decision had to be unanimous, and that means all 12 of them would have to agree on the verdict. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial. And in that case, you would have what's called a court or bench trial. And that means that instead of the jury hearing the evidence, the judge would be the one who would hear the evidence apply the law. You decide whether or not to state proof or guilt by proof beyond reasonable doubt. You understand that?
The judge explained to you that if you didn't want to enter pleas, you have a right to have the trial, a jury trial, or a bench trial. Right, but he just wants to make sure you understood that you have that right.
Okay, you understand that?
yeah.
And are you having any trouble hearing me?
No, just,
Okay, I just make sure I'm not, because most of the time people say I talk too loud, and over the years I've tried to dial it back a little bit, and sometimes go too far, so I just want to make sure.
no, you're fine.
All right, thank you. All right. Now, you have a right then to confront the witnesses against you in open court and to cross-examine them through your attorney. So what that means is that any trial will be public, and the witnesses have to come into the courtroom and testify in front of you and your attorney, and anyone else will be present during the proceedings. After the prosecutor was then asking questions of the witness, then your attorney would ask questions. That's called cross-examination, and the purpose of that is to bring out evidence that helps your side of the case. You understand that?
Yes.
Under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily at your request, court issues a court report that's a subpoena. That would force those witnesses to come to court to testify against you, even though they didn't want to be involved at all. That's the same process by which witnesses against you are required to come in to testify before the state. Do you understand that?
Yes.
Under the Constitution, you have a privilege against self-incrimination. And what that means is that you cannot be compelled or forced to testify in this case at any time, including trial. So, no one can make you testify. The prosecutor can't, the judge can't. It is your decision. And if your decision is to not testify at the trial, the fact that you did not testify cannot be used against you in any way by any person at any time in proceedings. And in fact, no one's allowed to talk about it if you don't testify during the proceedings, except in one situation, and that is if you have a jury trial and you do not testify. Then the judge does instruct the jury that because that is your right, they cannot take it into consideration or use it for any purpose whatsoever. Do you understand that?
Yes.
Now, under the Constitution, Mr. Smith, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense. What that means is that the burden of proof isn't on you to try to show you're not guilty because you've been indicted with the charge. In fact, under the law, you're not required to present any evidence at all at the trial in your own defense. Now, you may, but you're not required to. Whether you present any evidence or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of the offense charge by proof beyond reasonable doubt. And that's the highest burden of proof that is known under the law. You understand that? Now, originally you entered a plea of not guilty, Mr. Smith. Plea of not guilty, denied the allegations in the indictment, denied you committed any crime, and then exercised all the rights we just talked about here this morning. Now, if you change your plea from not guilty to guilty, that is the opposite of not guilty plea. Guilty plea admits the allegations in the indictment, admits that they constitute a crime, and that you're the one that committed that crime. And again, as amended with the last part of that being deleted. And that plea would waive or give up all of the rights that I've described for you this morning, except your right to have an attorney, because you always have a right to have an attorney no matter what your plea may be. But with that exception, your plea of guilty waives gives up the right to have a jury or court trial. Waives gives up your right to confront the witnesses against you and cross-examine them through your attorney. Waives gives up your right to use the power of the court to compel or force witnesses to come into court for you the way the state does. Same way the state does. You waive and give up your privilege against self-incrimination because you're the one that's saying you're guilty, and that's the evidence that's used to punish you guilty. Your plea of guilty also waives and gives up your right to require the state to prove your guilt or prove beyond reasonable doubt, because if you plead guilty, they don't have to prove your guilt. Plea of guilty subjection means sentenced immediately by the court, which is what's likely to happen here since there's only one sentence possible. And it waives, gives up any right to file an appeal that you think you could have had in this case up until this point in the proceeding. Now, and again, under the law, typically, if you thought that I sent you the maximum sentence, then you can file an appeal. But again, that's the only sentence that's available in this case, so you wouldn't really be able to appeal. You understand all that?
Yes.
If there is something that is appealable, that's rare, but if it is, you have to file it in 30 days from the entry of your sentence to be filed. You understand that?
Yes, sir.
And you're a U.S. citizen, Mr. Smith?
Yes, sir.
And you're entering into this agreement to plead guilty here today to reduce charge voluntarily.
Yes.
There you have it. And before I go further, does the state consult with the representative of the victim since she's of the younger age?
Yes, Your Honor. The state consulted with the victim's father on February 16th and approved this agreement.
Now, Mr. Smith, do you have any questions about the amended charge or the penalty?
No.
You understand? And you understand the sex offender registration requirement as well?
Yes, sir.
Do you have any questions about the plea?
No.
You understand? Do you have any questions about the constitutional rights I've explained to you here today? You understand those? Do you have any questions about the plea of guilty, what it means, or what the consequences of that will be if you enter it here today?
I understand.
Okay. And no questions then? Okay. Is there anything you'd like to speak with Ms. Hackner about before we go any further?
Oh.
Good.
Okay.
Okay, all right then. Okay. Have any questions about anything that I've explained to you here that Ms. Hackner hasn't explained to you?
No.
Then is it your decision, Mr. Smith, to go forward with this agreement to plead guilty as we've just gone over in the document you signed last week, and to enter a plea of guilty to the reduced charge of rape with the deletion of the allegation of the age of the victim being under 10 years of age, a first-degree felony, which would carry a mandatory sentence of 10 years at least before parole and possibility of life, and resident requirement to register sex offender. Okay, is that your decision?
Yes.
All right. I didn't say that there's also a possible fine of $20,000. I never really fine, so I just want you to know that. All right. Then, as to count one, which alleges an on or about the period of September 26, 2008, continuing through September 26, 2017 in Highland County, Ohio, that John E. Smith did engage in sexual conduct with ZC, the initials, not the spouse of the said John E. Smith, or being the spouse of the said John E. Smith, but living separate apart from the said John E. Smith, the said ZC being less than 13 years of age, and the parenthesis describing the act alleged of vaginal intercourse, in violation of section 2907.02A1B of the Ohio Revised Code, charged with rape, a first degree felony, carrying a mandatory sentence of 10 years up to life, a possible fine of $20,000, and a requirement that you be designated as a registered as a sex offender subject to lifetime registration should you be released from custody. How do you plead?
Guilty, Judge.
All right, thank you. You can see. All right, the court finds that on this date, open court, the defendant was advised of all of his constitutional rights and made a knowing and intelligent and voluntary waiver of the same pursuant to Rule 11. Plea is accepted and ordered filed. Defendant is found guilty of the reduced charge as set forth in count 1 of rape, a first degree felony. Counts 2 through 5 are dismissed. And given that this is a mandatory sentence, there's only one sentence possible, as I indicated earlier, there's no value to having it presented in court, and not requested. So I will go ahead and proceed with sentencing. Prior to that, I'll go through the sex offender registration explanation. Now, because you've been convicted of rape, first degree felony, Mr. Smith, you are hereby designated as a Tier 3 sex offender, child victim offender register. That means that you're going to be required to register in person if you should be released from custody with the sheriff of the county in which you established a residence within 3 days of coming into that county. And currently your effective residence would be Highland County. But if it should be something else, another county, then you would register with the sheriff of that county. You have to do that within 3 days of your release. Now, in addition to registering in the county where you're residing, you are also required to register in person the sheriff of any county in which you will establish a place of education. If you're doing any kind of college or any kind of job training, vocational training, etc. And you have to do that immediately when you go into that county. If you are working in a different county, then you would also be required to register with the sheriff of that county if you work there for more than 3 days in a row, or more than 14 days in any one calendar year. So it is possible that you could be required to register in as many as 3 different counties, where you're living, where you are working, and where you may be going to a place of education attendance. For purposes of this law, working includes doing community service or volunteer work. Now, if you should move into another state to reside, or go to a place of education in another state, or work in another state, then you'll be required to register in the county where that is taking place in that state with the sheriff or whatever public office is charged with the responsibility for maintaining sex offender registration information. Now, if you change any of those places, then you must, before you do that, if you're going to change your place of living, you must provide that written proof of that before you do. And if you're going to go, and if you're going to change your place of education, then you must also do that. That has to be more than 20 days for any change. Now, with employment, you don't have to report that until you've been there for more than 3 days, because again, you don't have to register if you're there less than 3 days temporarily. Now, if any time you should not have a fixed address, then you'd be required to provide the sheriff's office with a detailed description of where you'll be staying, intend to stay, and then later than the next business day after that, if you do obtain a fixed address, you must register with the sheriff of that fixed address. Now, you're also required to provide the sheriff of your residence registration county Any information of where you may be temporarily if you're going to be gone for 7 days or more. So if you're on vacation, visiting family, if you're in a hospital, if you know you're going to be in a hospital, if you're having rehab or something like that, and you're going to be away from your residence for 7 days or more, then you're required to notify them of that as well. Provide them that information, which is your address and how long you'll be with that other location. Now, you're required to verify your information every 90 days. And you have a window of 10 days before that date. So you can't do it any earlier than 10 days before, but every 90 days, the 90 days. It has to be in person. It can't be over the phone or online or by Zoom or Skype or anything like that. You have to do it physically. You're also required to notify any intentions to travel internationally, and that would be a violation of federal state law if you fail to do that. Now, the address that you'll be registering with right now will be the sheriff's office in this county at 130 Homestead Ave. Now, if you fail to comply with any of these requirements, I didn't neglect, you're also required to provide written notice within 3 days anytime you change your vehicle, your email address, any kind of internet identifier, or the telephone numbers that are registered to and used by you to the sheriff. Now, if you, like I said, if you fail to comply with any of these conditions, then you could be subject to being prosecuted under Chapter 4950 for a felony depending upon which act it was, and oops, signed on the wrong line. Okay. And you'll sign right there next to where I scribbled out where I signed on the wrong line. I put an X and signed your name as John E. Smith, and this simply is acknowledging that you had these requirements explained to you. Okay, we'll do that, and we can copy that for everyone later. Yeah, I'm just gonna get in here and tell her that we're here so that she knows that. So the cancel, your cancel Zoom. All right, and this is your signature then on this form, Mr. Smith?
Yes, sir.
All right, and I'm gonna put the date next to it, 2/22/22. All right, now we'll proceed with matter of sentencing. Anything from the state regarding sentencing?
Only what is contained in the plea agreement, Your Honor.
There's not a representative victim who wishes to address the court.
That's correct, Your Honor.
All right. Hapner on behalf of the defendant.
Thank you, Your Honor. We do have what is contained within the plea agreement. Mr. Smith did ask me to ask if we can have a report date in 3 days. The place where he has been living has been sold, and the marital home, his wife Terry informs me that she is in the process of selling that, so we'll need to sign some documents on that. And we just wouldn't be easier to have those signatures here as opposed to trying to send them to them in written.
Okay. Mr. Smith. say. You're not required to say anything, but this is your opportunity to say anything you would like the court to consider.
Well,
Recording in progress. Recording stopped.
All right. Well, inasmuch as this is a mandatory sentence, it's a order of the court that you be and are hereby sentenced to a mandatory term of at least 10 years up to life imprisonment, although it is subject to parole. Now, upon completion of that sentence, as I said, technically, if your sentence is life, but you could be released on parole prior to that. But in addition, you would be then under post-release control supervision for a period of 5 full years. And what that means is that you'll be supervised under the term set by the adult parole authority. And if they determine that you have failed to comply, then they can return you to prison to make you serve an additional period of up to 9 months for any one violation, up to a maximum of half of your prison term for all violations, which would be 5 years. But that's also the maximum that could be. Now, in the event that you are convicted of a new felony, then in addition to whatever sentence the judge of the new felony could impose upon you, if you commit that while you're under post-release control for that 5-year period, then the judge in that case would sentence you to an additional period of 1 year or whatever time left on that 5 years of post-release control, whichever is greater, and that would have to be served in second place to the sentence in the case. Typically I wouldn't grant a delay. What is the timeline in terms of this sale that you're talking about? When are you scheduled to sign these papers?
it should be, within the next few days.
Okay, what is it you have to sign? Is a contract for sale already signed? You have to do the closing, or what is it?
It's just a closing.
And who's handling the closing?
Okay.
Pardon me?
Okay.
So,
Then you go.
What real estate firm?
I think isn't technically doing the actual closing.
Terry's handling it. Once she does, if I make them sign paper.
I was under the impression that Technicolor was doing the actual, I'm not sure who the realtor was, but I was under the impression that Technicolor was doing the actual
But
closing.
there's a contract signed.
But my understanding is there's a contract signed and they're to be closing any day now. That's what I've been told. That's basically consistent with what Mr. Smith said, that closing is that.
And this is a home that you and your wife are living in?
Yeah.
All right, you haven't given her a power of attorney or anything?
We're supposed to give her power of attorney, but it hasn't been in effect yet.
All right.
I can draft the power of attorney on. I think we were hoping to have the closing done prior to the time of the plea.
All right. All right. Well, I'm going to give you this opportunity then. I'll give you report to the sheriff's office at 9 a.m. next Monday. That would be February 28th. Okay. And if you're not going to get it done by then, you'll need to sign a power of attorney. Talk to the Hackner or any attorney for that matter, to have, give the power of attorney to someone, whether it be your wife or someone else that you trust, to do that for you. I'm not going to just leave this thing open. Back, I haven't granted one of these for a long time. But I know you've appeared before an attorney, so we'll defer that. But if you fail to appear, then, and we're going to give you an assignment notice here. So your order to report to the jail 9 a.m. February 28th. If you fail to appear, you'll be prosecuted for an additional felony. And because this is going to continue on the same bond and your OR. If you fail to appear, you'll be prosecuted for failure to appear and also subject to having your bond forfeited. So your bond will continue until, the, report date.
Thank you, Ron.
All right. And if you were due to report of probation, you know, you do that, this week if you're due to report.
Yeah, I'm supposed to see him today.
All right, okay, well, we'll go right down there and then all right, anything further, council?
No, no.
Jail time credit, Your Honor.
Oh, we don't have any jail time credit, let's see, did you spend any time in jail, Mr.,
I spent one night in jail.
okay, I look here, yeah, you were arrested on 25th, looks like you posted on a, 26th. Is that right?
Yes.
So you spent one night, all right, so 1 day of jail time credit. Thank you for bringing that up, I asked the bail if it was in there, but I should have brought that up. Anything further, council? All right, thank you. You can go back to your office for this, you're gonna try to do all that.
You better be by my office on
Okay, that's
our.
fine. Okay, wait, all right. Okay, Ms. Hapner's here, we just finished this hearing, she's gonna go to her office, she'll be back here, she'll be on the call in about 8 or 10 minutes, so you guys wanna just hang loose, when you do that. Let's see, now, who's the person passing us? Is that hers as well?
Yeah.
Okay, all good, Ms. Hapner. All right, I'm gonna step off here, for a few minutes, let Ms. Hapner, right?
I'm credit, Your Honor.
Okay.
Entries tonight, and then here's the 3-4 meeting next week.
Okay. Then we'll have people in contract, and sit together on that. I thought there was someone for that hearing. And I saw it Zoom, I'm thinking, okay, that must be too many people, so. That's, it happens. And I'm glad to do that, because I've run people out of the big witness office before, you know, and to show them the system.
Browning's father went off to it.
Oh, is it?
Yeah, that's what Browning's at now.
Oh, yeah, yeah. Okay. Well, that's all right. All right, well, we're operating on a dog.
This is from Mr. R.G. Judge. Please.
Yeah. Yeah, once you brought that up to me. All right, let's do John Richards first since he's a mess.
Okay.
All right, this is State of Ohio versus Johnny Richards. And you're Johnny Richards appearing from the screen that's marked Massey House.
Recording in progress.
Can you hear me, Mr. Cole? I'm muted. All right, this is case number 22CR0011, State of Ohio versus Johnny Richards. And are you Johnny Richards appearing from this Massey House? All right. Mr. Richards' attorney is Catherine Packner. She's appearing from her office, and appearing from his office is the Assistant Prosecuting Attorney Adam King, representing the state. This hearing is being conducted by Zoom. It's the final pretrial. Packner, you and your client both agree that this matter should be conducted by Zoom rather than him appearing personally before the court.
Yes, we can hear
And you're all right with that, Mr. Richards? You're all right with that, Mr. Richards?
Yes, sir.
All right. Now, the defendant is charged with aggravated possession of a fentanyl-related compound, fourth degree felony, and aggravated possession of methamphetamine, a fifth degree felony. We have a trial date set for April 11th. This is the first pre-trial actually today. It was actually postponed from last week, I believe. Well, actually, I think we just went ahead and set the matter for pleas today. Trial date set for April 11th. Now, I've been presented with a plea of guilty form, Mr. Richards, which is a document that's prepared by the prosecutor's office from a form they have in their computer. It is 3 pages long. I'll hold up the first page of the camera to show you that this is your form. It's in your case number and the information says you're going to plead guilty. See that there?
Yes, sir.
And then on page 3, about halfway down, there's a sentence that says, I enter the plea voluntarily. Immediately below that, there's a line under which to put a signature defendant. I'll hold that up to the camera. And is that your signature there under that line that says, I enter this plea voluntarily?
Yes, sir.
All right. And when did you sign this document, Mr. Richards?
April 15th or 16th.
All right.
That's great. Driver's license there.
All right. And were you with Ms. Hackner and she went over it with you when you signed it?
Yes, sir.
All right. She fully explained everything to you?
Yes, sir.
And you understood that it was agreed to plead guilty, which means there's not going to be a trial in your case, so the next step would be a sentencing hearing?
Yes, sir.
And do you think you had enough time to fully consider this matter before making this decision to sign this document?
Yes, sir.
And are you entering into this plea agreement voluntarily?
Yes, sir.
Right now, the agreement states on page 1 that you're going to plead guilty to count 1, aggravated possession of fentanyl-related compound under 2925.11, a fifth degree felony. Actually, it says on the indictment it's a fourth degree felony. On the front page, Mr. King, but it isn't. It's a fifth degree felony, isn't it?
Yes, sir.
Yeah, exactly. Right. Okay, so the plea agreement is correct. All right. Now, it further states that you understand that the maximum possible prison term for that convicted would be 12 months, so the minimum of 6 if you're sentenced to prison. There's a possible fine of up to $2,500 and a possible license suspension of 6 months to 5 years. Do you understand that?
Yes, sir.
Right now, are you currently facing any felony charges in any other jurisdiction?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony from any jurisdiction?
Right now.
And what is the charge down there?
25.
All right. And when will you put on probation on that case?
September.
All right.
September.
All right. Okay. Well, I see this offense was committed, if the plea guilty was allegedly committed back on June 29th, so it shouldn't affect that. But any event that you should ever, be sentenced to prison in both counties at the same time, then those sentences could run consecutively, meaning one after the other. You understand that? Now, other than the Brown County case, you have any charges pending in any other jurisdiction?
No, sir.
And you're not on probation or community control?
If I may, we should wait sentencing, in this court with another case.
Oh, okay.
This case, that would be 21 CR 180, set for sentencing on 116.
Oh, okay, all right. So, again, if you are convicted of the two sentence charges in this case court, plus the Brown County, this could all be one run consecutively, one after the other, you understand?
Yes, sir.
Okay. Now, under the law, if you are, well, let me back up. Other than that, no other charges out there in any other courts or,
No, sir.
all right, thank you.
I do have, municipal court for every hearing on an ODI.
Okay, but that's a misdemeanor though, right?
Yes.
Okay, so it doesn't have any possible prison time, all right?
Right.
All right, now, under the law, if you are ever sentenced to prison on this offense, and I think in the other cases, that a fifth degree felony as well, Mr. King, I forgot about
It's 2 5th-degree felonies, Your
it.
Honor.
In the other case, all right. All right, so if you are ever sentenced to prison on any of these charges, then once you complete the prison term that's been imposed by the court, it is possible the adult parole authority may exercise their option to put you under post-release control supervision for a period of up to 2 years. And they don't have to do it, but it's up to them. The judge doesn't have anything to do. If they decide to do that, that means you can be supervised by a parole officer in the term set by the authority. And if during the period of time that you were being supervised, they determine that you have failed to comply, they could return you to prison even though you served the entire term set by the court for an additional period of up to 9 months during one violation, up to a maximum of half of whatever prison term the court imposed for all violations. But if you committed a felony, then in addition to whatever sentence the judge in the new case imposed upon you, the judge would also sentence you in this case for having committed that new offense while under supervision in this case to an additional period of 1 year or whatever time left on that 2 years of post-release control, whichever is greater. If that occurred, that would have to be served consecutively the sentence in that new case. You understand that? Now, under the law, I'm required to sentence you to prison for these offenses. This offense, I can't impose community control or probation. And that means you can be supervised for a period of up to 5 years under term set by the court. And during that period of time, probation felt you were not compliant, they would file a written notice of that to the court. You would be entitled to have a hearing and be represented by counsel. If the outcome of that hearing wasn't you failed to comply, and at that time the court would revoke community control and then sentence you to prison for a period of 12 months, in this case, as well as the other two cases, and for we all be served consecutively and fine you in this case an additional $2,500. You understand that? Do you understand that?
Yes, sir.
Okay. All right, now, the charge of Rutledge's count 1, that on or about, I'm going to make a change on the front of this indictment. It's not part of the indictment, just the cover sheet, to make that a 5 instead of a 4. All right, now, the charge alleges on or about June 29, 2021, Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance to whether fentanyl-related compound, a violation, Section 2925.11 of the Higher Advice Code. So that's the charge that you're facing, a 5th degree felony, carrying possible prison term between 6 to 12 months, $25, and life suspension, 6 months. Now, Mr. Richard, do you understand what it is you've been charged with, what the state said you did, when, where, how, and that you did it? And have you discussed the nature of the charge, the evidence of the case, possible legal issues of the case, possible offense you might try to raise in trial, and possible outcome of the trial with your attorney?
Yes, sir.
And are you satisfied with your advice and competence in this matter? Are you satisfied with her advice and her competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made against you plead guilty here today?
No, sir.
Now, on page 2, there are a couple of lines that are printed in bold and underlined near the bottom of the page. So I'll read those and they read as follows. Defendant shall enter a plea of guilty to count 1, state and dismiss count 2, state defense joint to recommend committing control of drug force. Is that your understanding of the agreement?
Yes, sir.
Anyone promise you anything other than that to get you to plead guilty here today?
Yes, sir.
Under the law, the matter sentence is up to the judge, not the party, so even though there's a recommendation to get community control or probation, you go to drug court, I'm not required to follow that, I could decide after I've considered everything submitted, that you should be sentenced to prison instead of getting community control, you understand that?
Yes, sir.
Alright? Now, do you hold any license or certification from any state, organization, or any state governmental body that regulates any trade or profession or, occupation?
My driver's license is suspended until May 2nd.
But other than that, this is something like, if you had a license to, be like an STNA in a nursing home, or a vet tech, or a barber, or something like that.
Yes, sir.
Okay. Alright, now, you have constitutional rights which understand the court and accept plea guilty from you. First of all, you have right to counsel. Ms. Hackman was appointed to represent you. Now, her appointment wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you would like her to provide. So if you decide you don't want to do this, that you want to contest or fight these charges, and she'll still continue to represent you, including a trial if that's what you want. You understand that? All right, now in the Constitution, you have the right to have a jury trial in this matter. Mr. Richards, in which 12 people will be selected from a group of citizens that reside in this county who are summoned for jury duty on your trial day, and those 12 will be the jury. They will hear the evidence and then be instructed on the law. Then that jury of 12 will decide by unanimous verdict, meaning all 12 have to agree, whether the state proves your guilt of the charge. Now, if you decided you didn't want to have a jury trial, but you don't want to plead guilty, you can waive in writing, which means to give up, and your right to have a jury trial. In that case, you have what's called a court or bench trial. That means that instead of a jury hearing the evidence, the judge will be the one to hear the evidence, apply the law, and decide whether or not the state proves your guilt or prove beyond a reasonable doubt. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to confront witnesses against you and cross-examine them through your attorney. What that means is that the witness against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, then your attorney can ask questions, and that's what's called cross-examination. The purpose of that would be to try to bring out evidence that help your side of the case. You understand that?
Yes, sir.
And under the Constitution, you have a right to compel the court to compel or force witnesses to come into court to testify on your behalf and say it's a state. So if you have witnesses you're not certain going to come in voluntarily, your request for court issue court orders called a subpoena, that would force those witnesses to come to court and be able to testify if you wanted them to, even though they didn't want to be here, which is the same way the state's witnesses are required to come to court. You understand that?
Yes, sir.
Right now, under the Constitution, you have the privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person. No one can even comment about it, except in one situation. That is, if there's a jury trial and you want to testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Right, under the Constitution, Mr. Richards, you are presumed innocent of this charge and shall prove guilty by the state of Ohio on every essential element of the offense. So what that means is that the burden of proof is on you to try to prove you're not guilty simply because you're accused. In fact, under the law, you're not required to present any evidence at all at trial. You may, but you're not required to. Whether you present any evidence in your defense or not, the burden of proof will remain upon the state to prove your guilt on every essential element of the offense charge by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Right now, you entered the plea of not guilty originally. The not guilty plea denied the allegation, denied you committed a crime, and to exercise or invoke all of the rights that I just described. Now, if you change your plea from not guilty to guilty in this charge, count one, that's the opposite of the not guilty. The guilty plea admits the allegations in the indictment, admits that they constitute a crime, and admits that you're the one who committed that crime. And that plea waives all the rights that I described to you today, except the right to have an attorney, which you always have, no matter what you plea. But with that exception, your plea of guilty, you waive and give up your right to have a jury or court trial. You waive and give up your right to confront witnesses against you to cross-examine for your attorney. You waive and give up your right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. You waive and give up your privilege against self-incrimination because the state of guilt has find you guilty. The way we give up presumptive innocence, because we say it, really, the state's not required to prove it. It also subjects you to be sentenced immediately by the court, and finally, waives or gives up any right to file an appeal that you think you may have had up to this point in the case. Now, if you, are sentenced to the maximum sentence or under certain circumstances, it could be an appeal filed. That would have to be filed within 30 days of your sentencing entry being filed. You understand all of that?
Yes, sir.
And, Mr. Richard, are you a U.S. citizen?
Yes, sir.
And you're entering into this plea, agreement voluntarily.
Yes, sir.
You have any questions about the charge and possible penalty?
Yes, sir.
You understand?
Yes.
Any, questions about the plea agreement?
Yes, sir.
You understand?
Yes.
Any questions about the, constitutional rights that I've explained to you?
Yes, sir.
You understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter that plea here this morning?
Yes, sir.
You understand?
Yes, sir.
Is there anything you'd like to speak with Ms. Hackman about before we go any further? I forgot to tell you at the beginning, I can put you in her into a breakout. Talk alone without anyone else sitting here and you can talk to her. But do you need to speak with her about anything?
I would like to know what there is.
All right, well, we'll put you in that breakout, but I should have done that at the beginning, but we'll be doing that. In your discussion with Ms. Hackman?
Yes, sir.
And do you have any questions about anything I've explained previously?
Yes, sir.
All right, then is it your decision to withdraw your non-guilty plea, plead guilty to the charge in accordance with the agreement that we've just gone over?
Yes, sir.
All right, then as to the charge, which alleges that on or about June 21, I believe it is, June 29, 2021, in Hyden County, Ohio, you did not obtain, possess, or use a Schedule II controlled substance with a fentanyl-related compound violation section 25.11 Ohio Revised Code, a fifth-degree felony carrying possible prison term between 6 and 12 months, fine $25,000, and possible license suspension, 6 months to 5 years, how do you plead?
Guilty.
All right, the court finds on this stand, of course, defendants provide all his constitutional rights, make no intelligent voluntary waiver saying, from 11 pleas except for 5 found guilty count 1, 53 felony, and charged therein, count 2 is dismissed. Court will refer the matter for pre-sentence investigation, bond will be continued, and sentencing is, I believe, March 16th. Is that at 1 o'clock this afternoon? Do you have that on the calendar there?
I think so, we just check.
Is it
Yeah,
30?
1:30, all right. So, since you've already been referred for PSI and the other one, I don't think that'll be any problem for this full to add this to that. All right, anything further, council?
There.
All right, thank you. All right, Ms. Fleming, if you're there, would you turn on your screen and activate or unmute your mic, please? All right. It's case number 21 CR 162, State of Ohio versus Stephanie P. Fleming. You're Stephanie P. Fleming, appearing there on the screen, Mark Stephanie Fleming. All right. You might speak up or turn your volume up. It's real faint. I heard you. Okay. I heard you then. All right. Ms. Fleming is charged with a 4-count indictment, 2 counts of aggravated trafficking and meth, 2 counts of aggravated possession. This matter was set for a pre-trial this morning, and a plea form has been presented to the court. However, the court will note that I had released Ms. Fleming on an OR on the condition that she be taken down to stepping stones, and I received both a fax from the probation department as well as one from the counseling center indicating dated the 21st that Ms. Actually, I guess that was the date of their the date of the report, indicating that she indicated she signed a plea deal, and since she was going to prison, she wanted to spend time with her family before going to court on the 16th. Today's the 22nd. Probation indicated she had not reported. And so, Ms. Fleming, you're actually an absconder, so I'm going to order you to report to the jail by 4 o'clock today. If you don't, I will issue a warrant for your arrest, and I will set this for a plea hearing in front of the court, or possibly by Zoom from the jail. Ms. Hackner, are you available Thursday morning?
The 24th,
Yes.
no, Your Honor, I scheduled it for that 9 o'clock today at 2 miles, and I watched you for that.
Okay. How about Monday, the 28th? Are you available anytime then? All right, let's set this for hearing at 2:30 on the 28th. So, no, you're reported to jail. You were released from jail on the condition that you remain at the counseling center, and you left there. And so, whenever that happens, you're supposed to report back to jail, or you're an absconder. I did not release you on bond unless you were to stay there. So, you report to jail by 4 o'clock today. If you don't, the court will issue a warrant for your arrest. And then the hearing is set next Monday at 2:30 a.m. I'm sorry, p.m. And if you fail to report back and don't appear to that hearing, you will be subject to being prosecuted for an additional felony for violating the OR. All right. Do you have any questions, Ms. Fleming? All right.